Thank you, Mr Chairman, for a call on this bill. Mr Chairman, it's hardly surprising, really, that we're considering a bill that involves yet again another denial of due process, potentially another denial of access to justice, because this government, indeed this minister, is establishing a very strong track record in exactly that issue. We most recently had the Public Health and Disability Act, which was at least explicit about denying access to the courts for a group of people who were desperately in need of it. And Mr Chairman, now we have legislation that deals with the process end of trying to get access to justice, and it starts putting up the barriers and the humps to get in the way. Now, the Minister may well consider she's done a good job at watering down some of the worst aspects of the legislation as it was introduced. But there are still barriers and there are still problems with this legislation. And I think it's instructive, Mr Chairman, to note that since the present legal aid regime was put in place, the number not only of lawyers doing legal aid since the beginning of last year, but also the law firms now allowing their lawyers, their solicitors and partners to do legal aid has been dropping consistently and dramatically. And we've said, and you hear it from lawyers too, law partners now say that whereas once upon a time a lawyer with 2 or 3 years post-qualification experience could be put onto some legal aid cases, it builds up their experience, gets them a bit of court access, court time, they no longer do it. Because with the fixed fee regime and with the administrative process that it now entails, it is getting harder and frankly less viable for law firms to do it, and lawyers, particularly those practising on their own account, are now saying it is just too much, and they are getting out of it. And it is interesting to note now the government having to put, or the Ministry of Justice having to put together a program specifically to attract senior counsel back into doing legal aid work, because the present regime isn't working. Well, Mr Chairman, this bill is not going to help, and if anything, it is going to make it worse. Mr Chairman, we should not, when we are thinking about those who are dependent on legal aid, overlook just what sort of a barrier $50 is in terms of making an application or contributing to those initial costs or legal costs that are required. For the impecunious, the destitute, the poor, those who find themselves either facing the full force of the police and the coercive arm of the state and having to defend themselves and, most importantly, their liberties against it, actually having access to legal aid is very important. And if you don't have $50, you don't have $50. And under the fixed fee regime that now applies to legal aid, whereas before a lawyer who is making the application representing their client could in reality absorb that $50 in terms of the charge they pass on to the Ministry of Justice, they now cannot do that under the fixed fees regime. And unless there is a change there, and who knows what will happen there, unless there is a change there, Mr Chairman, then it is simply going to get harder for those who are dependent on legal aid to stump up that $50. They will be dependent on the generosity of legal counsel who are themselves making the applications for legal aid in order to represent that client, to have to either pay it themselves or in effect accept even less than the specified fees regime that is in place at the moment. That's the insidious nature of just that part of this bill, and that's why this bill continues to create a barrier that we can all foresee will have very real effects for those who would otherwise be dependent upon it. And so then there is the arrears issue, this insidious notion that when you are needing legal assistance, particularly if you are facing a criminal charge, and when we claim that we have in our system, our constitution, where the state can come after people and with prosecutions and put their liberty at risk, that we say, yes, you can get access to court and get your case heard, to put in place a situation where a previous grant of legal aid may give rise to a debt that, Mr Chairman, Mr Chairman,
I've called Andrew Little.
That may have given rise to a debt that then may count against, if it's unpaid, against a future legal aid grant, Mr Chairman, that goes against a fundamental constitutional principle that when the state is coming after you and putting your liberty at risk, you must be allowed access to the court to be heard. Not only access to the court, Mr Chairman, but also adequate representation. Representation of a quality and nature that befits the charge that the person is facing. And so that particular provision, innocuous as it may seem on paper, and as the Minister may make out, that particular provision, Mr Chairman, we can foresee is going to also create a barrier to access to legal representation at a time when a person who is dependent on legal aid is going to need it most. And so that is yet another reason why we will be opposing this bill. Mr Chairman, we have already seen in the consideration to date, and it's not complete yet, we have already seen in the consideration of the Family Court Proceedings Reform legislation just how difficult it is going to get for people in the civil jurisdiction to get access to legal aid. And in that particular case, it is going to get harder for those going through a family dispute, mainly a separation, an appearance in a dispute, to get access to legal aid. Certainly legal representation at the time they most need it, which is when their particular situation and the legal ramifications of it are being talked about. But also, disturbingly, Mr Chairman, counsel for the child now is going to find it much harder to get support, state support, to play their important role, because that role is more or less legislated out under that particular bill. And it all ties in with what this bill is trying to do, which is to once again minimise and reduce the cost of legal aid to the state. Now, the Minister makes very fine statements about the importance of legal aid, and legal aid is a big cost, about 50% of the cost of the justice vote. But, sir, we have that in a civilised country like ours because it's important. It's important for people to have access to adequate representation when they are in court. And, sir, when we think about legal aid, it's an area in which we should proceed with caution and with care and with respect for that constitutional right for people to be represented in Her Majesty's courts, because when issues of rights are being determined and when issues of liberty are at stake, then there is no cost too great to ensure that a person's rights are fully observed and respected, and they can get an audience and a judge can make a considered decision on the basis of good quality representation. There are some respects in which if we don't meet the proper cost of legal aid, the proper cost of representation of people when they are before the courts, that cost will be picked up elsewhere. And it will be picked up, as my colleague Leanne Dalziel referred to, as unrepresented people making guilty pleas that with proper consideration and access to legal aid they would not otherwise make. And that may have implications then for the application of other legislation, like the three strikes legislation, that may see people serving extensive sentences of up to 14 years for what might otherwise be considered trivial acts of street thuggery or street burglary. And so, sir, we take this seriously, and notwithstanding the positive changes and the general direction that this bill has taken, we still see in these provisions, in this part of this bill, some real problems, some real concerns about access to justice and the observance of people's rights.
Mr Chair.
Scott Simpson.
I move that the question be now put.
I'm going to hear from Carol Beaumont.
Thank you very much, Mr Chair.